This fall, the Supreme Court will hear New York State Rifle and Pistol Association Inc. v. Bruen. The case could change the future of gun reform in America. Since 1913, over 100 years, New York State has required an individual to prove proper cause in order to obtain a permit allowing them to carry a handgun in public. For that license to be unrestricted, the applicant needs to demonstrate a special need for self-protection distinguishable from that of the general community. The plaintiffs in this case include two men from New York whose licenses were denied. They claim that they, as law-abiding citizens, have a Second Amendment right to carry their guns in public. But the Second Amendment has never been unrestricted. In fact, in the state of New York, firearms regulations even predate the Constitution itself. By 1785, New York had laws about when and where firearms could be used and restricted the storage of gunpowder. This has been the case all across America for much of our history. As early as 1686, New Jersey was the first colony to codify a law prohibiting concealed carry. In 1852, Hawaii enacted the Act to Prevent the Carrying of Deadly Weapons, which prohibited citizens from carrying unauthorized weapons, including pistols. Violators faced fines and imprisonment. This law remained in effect even after the United States annexed Hawaii in 1898. And these are just early examples of America restricting the public carrying of firearms. The examples are endless. In more recent years, the court has continued to recognize the rights of states to regulate firearms. It was even affirmed in 2008 in the case of DC v. Heller, which is considered a victory by gun rights groups. Conservative Justice Antonin Scalia wrote this: "Like most rights, the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose." The Heller decision also stated that the majority of the 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment and called laws regulating firearms presumptively lawful. The history of firearm regulation in America dates back before our independence and has been supported by centuries of precedent. But the former president and GOP senators pushed hard to confirm far-right justices with self-described radical views on the Second Amendment.
That sounds kind of radical, to say felons can have firearms.
If these justices have their way and subvert centuries of settled law, it could lead to more gun violence across the country.